Hello, my name is Camille Jorge, and for my human rights project, I choose to do the European Court of Human Rights. In a world where fundamental freedoms are consistently discussed and sometimes challenged, understanding the system designed to safeguard them is increasingly important. As Jack Donnelly discussed in Universal Human Rights, these rights are not merely abstract concepts, they are legal entitlements established to ensure individual dignity. Under Coffin in Human Rights, a very short introduction further highlights the inherent and undeniable nature. This analysis will examine how these rights are put into practice across Europe through the European Court of Human Rights, a unique international court dedicated to upholding the European Convention of Human Rights. It will cover its function, its work mechanism, its impact within Europe, and its significant role in a case especially related to immigration. So, what is the European Court of Human Rights? To begin, the European Court of Human Rights is distinct from institutions of the European Union, a common point of clarification, because usually when we talk about Europe, we usually come to mind the European Union, but just to be sure, the European Court of Human Rights came way before. It was established in 1959 in the post-wars of World War II, and the European Union is an organization that was established decades after that. So it serves as the juridical body established by the European Convention on Human Rights. It is a threat of the Council of Europe. This international organization was founded after World War II, as already said before, with a commitment to prevent future atrocities and securing peace through the protection of human rights. The court was established in 1959 to monitor the human rights of European and Council of Europe member states. As Helmut Philip Oss and Arias Demkoso explained in the work, the court originated from the post-war dedication. The court's primary function is to ensure that the 46 member states of the Council of Europe respect the human rights and the fundamental freedom outlined in the European Convention. This means its jurisdiction extends beyond the European Union, encompassing countries from Iceland to Azerbaijan. It operates as a supervisory body, processing applications for individual groups or even states who claim a violation of the rights under the Convention. A core principle guiding the court is subsidiarity. This signifies that the national authority holds the primarily responsible for ensuring the Convention rights. The European Court only intervenes after all available legal steps have been followed in the national system and has not resulted in a just solution, so the individual state can go for the European Court of Human Rights. It acts as a critical safety net, not a primarily legal avenue. Another key aspect of the court work is the interpretation of the convention as a living instrument, a very important point, because as the court was established in 1959, it's very important because it has already passed several decades and the primary function is still ensured because of this interpretation principle, because it will adapt as time goes by. This approach allows the court to adapt its understanding of the convention provisions to contemporary conditions and social change, ensuring its continued relevance and dynamic protections of human rights over time. Because as time goes by, all the society change. So to make sure that the things that are established in the European Convention and in the European Court of Human Rights in 1959 still are meaningful for the society that we have nowadays and for the problem that we face nowadays, this principle is a fundamental key. Second part, the court mechanism, how cases are processed. A very important point. How does a alleged human rights violation reached the court in Istanbul, France. The process throughout designed to make numerous applicants annually. Most applicants originate from individuals. They must first satisfy strict admissible criteria, and they have a very good showcase of how it actually occurs. So let me guide you through. First, applicants must have exhausted all effective domestic remedies in their own country, meaning that the case has been pursued as far as possible through national court. Secondly, the application must be submitted within 4 months from the date of the final national decision. Thirdly, the application must demonstrate having been a directly victim of a violation and have suffered a significant disadvantage. The case must also involve a right protected by the European Convention. These criteria are discussed by us and demigurs are essential for managing the court's substantial caseload and ensure its focus on significant human rights issues. So, once application is deemed admissible, the court attempts to facilitate a friendly settlement between the parties. If it isn't possible, the case proceeds to a chamber of 7 judges for exceptionally important case, or if a chamber relinquishes jurisdictions, a grand chamber of 17 judges will hear the case. The court judgments are legally binding on the respondent state and often require them to pay just satisfaction to the victim. Importantly, these judgments are often solicited to establish change to national laws, policy, or administrative practice to prevent a future violation. The Committee of Ministers of the Council of Europe then supervise the implementation of this judgment. So, very important point here is that after all the cases have been proceeded, to make sure that this won't happen again to an individual or any group state member, they establish that the country who has violated those laws has to change its law or its process system. And also they have a committee of ministers that goes to supervise the application and the implementation of the actions established by the court. Impact and efficiency in the European context. The European Court of Human Rights' impact on domestic legal systems across Europe is profound. Its judgments have led to significant reform, ranging from improvements in prison conditions and ensuring fair trials to protect freedom of expression and privacy rights. This influence reinforced the idea presented by Donnelly that human rights are not merely theoretical, but active force shape societies and governance. However, efficiency remains a continuous challenge, as us and Demigo show in their studies. The court faces a substantial backlog of application, resulting in lengthy proceedings. There are also instances of no compliance by states where judgments are not fully or promptly implemented, and sometimes political resistance from national governments. This current challenge tests the very authority and effectiveness of the court. It is crucial to clarify that the European Court of Human Rights relationship with the European Union. Although many European Union members states are also members of the Council of Europe and thus fall under the European Court of Human Rights jurisdiction, the European Court is not a European Union institution. As I said before, it comes way early than the European Union formation. And nevertheless, the European Union is legally obliged to respect the rights guaranteed by the European Convention through its character of fundamental rights. It largely mirrors the European Court of Human Rights. This established a complex but vital judicial dialogue between the European Court of Human Rights and the European Union on Court of Justice, working together to strengthen human rights protecting in Europe. And what I choose to do one important global challenge that I see related to the European Court of Human Rights and something very vividly present in Europe as in general, that's immigration case. And I'll dive through one specific case to show the effectiveness of the European Human Rights Council. Immigration case and the European Court of Human Rights. One of the most sensitive and frequently legitimate areas before the European Court of Human Rights involves immigration and asylum case. The movement of people across borders inevitably brings human rights consideration to the forefront, creating complex legal and ethical dilemmas for states. While national government retains sovereignty over immigration policy, these policies must always comply with the Convention. Drawing on the insights one would express from a report like McNeil-Gower and Dawson Immigration and the European Court of Human Rights, many cases concern the rights of individuals facing deportation or expulsion. Key articles frequently invoked include. So here are the principal articles that I usually mention in those cases. Article 3, Prohibition of torture and inhuman or degrading treatment. This is a parameter. The court will prevent deportation if there is a real risk that the individual would face torture or will in treatment in the destination country. Article 8, Right to respect for privacy and family life. This article is crucial in cases involving family reunification, separation, or the impact of deportation on an individual establishment life in his host country. Other articles such as Article 2, Right to Live, Article 5, Right to Liberty and Security, and Article 13, Right to Effective Remedy, are also frequently engaged. The European Court does not grant asylum directly, nor does it dictate a state migration policy. Instead, it reviews whether decisions made by national authority, such as refusal of entry, detention, or deportation, are in line with the human rights obligation under the Convention. For instance, the court has ruled against collective expulsion and has required states to provide individual assessment for asylum seekers. It also established the condition of detention for migrants and asylum seekers, ensuring they meet human rights standards. So they don't have a specific or guideline to asylum or to the immigration case, but they supervise each country's jurisdiction or decision if that matches with the court or the European Convention on Human Rights, if goes along, if respect all the articles, and then it acts up or against it. And the case example that I choose is Haisi Jama and others vs Italy in 2012. In this landmark case, the European Court of Human Rights examined the actions of Italy authorities who in 1999 intercepted a group of 24 migrants from Somalia and international waters off the coast of Libya. Instead of bringing these individuals to Italy to assess any potential asylum claims, the Italian authority transferred them back to Libya. The court found that the Italy had violated Article 3, Prohibition of torture and inhuman or degrading treatment, and Article 4 of Protocol Number 4, Prohibition of collective expulsion of immigrants, of the European Convention of Human Rights. The European Court decided that Italy had exercised jurisdiction over the migrants when it intercepted them at the sea, meaning its human rights obligation apply. Number 2, by returning them to Libya, Italy have exposed them to a real risk of ill treatment, as Libya at the time was known for human rights abuse against migrants and lacked a functional asylum system. This was a violation of Article 3. And 30, the return of the entity group without any individual assessment or the particular circumstance constitute a collective expulsion. It is forbidden by the Convention. This judgment was highly significant as it reinforced the principle that states have human rights obligations even when they are operated or conducted outside the national territory, particularly when they exercise control of individuals. It highlights the responsibility of states to protect individuals from serious risks, regardless of where they are intercepted, and to provide individual assessments for those who might need international protection. And this is a very important case because if you look by Italy's side, it was on international waters, but as they sent the ship back and didn't take any other further measure, they violate both Article 3 and Article 4 of the European Convention, what was a very important case in the European Court of Human Rights. And in conclusion to all of these analysis, I could say and affirm with all my Jewish and in conclusion, I could firmly affirm that the European Court of Human Rights is a living instrument for rights. The European Court stands as a cornerstone of human rights protecting Europe, from its post-war origin to its current engagement with complex issues like migration. It continues to interpret and applies the European Convention of Human Rights as a living instrument, as I said before, while it faces ongoing challenges related to case load, compliance, and political pressure. It endures work-shaped national laws, influence judicial practice, and provide a vital avenue for individuals seeking justice when their fundamental rights are violated. The European Court of Human Rights reminds us that universal human rights are not static. They require constant vigilance, robust mechanisms, and dedicated institutions to ensure they remain a reality for everyone. And as is shown by this analysis, one thing that I really look for in other human rights organization is how the European Court of Human Rights persists over time. It has almost decades that is already has been established and still work nowadays. It still address the problems that we face nowadays. And it's something for us to look forward or to see what is working and what could be applied to any further institutions that like the need to have more effectiveness, and they can ensure itself or establish itself through the passage of time.